This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we speak about why expert fees are owed because the plaintiff failed to accept a settlement offer which was greater than the amount of the eventual result of the case. And the fact that an award of zero damages constitutes prima facie evidence that an offer of settlement was reasonable. Wild Chang and Kenneth Lo appealed from a post-judgment order denying their motion to strike or tax costs. The trial court awarded costs to the defendants, Fire Insurance Exchange and Stacy Chern, after the trial court granted their motion for terminating sanctions and entered judgment in favor of the insurers. In Wild Chang et al. Versus Fire Insurance Exchange, the California Court of Appeals on December 19, 2024, concluded that an offer of settlement rejected by the plaintiffs required the plaintiffs to pay costs and expert witness fees after the case was dismissed with regard to terminating sanctions. Plaintiffs' insurance claim and consolidated actions were submitted for losses caused by a fire in their home in 2014. In 2016, Fire Insurance Exchange offered $19,925.91 in structural repairs, which plaintiffs rejected. In 2017, plaintiffs Chang and Lo sued Farmers Insurance Company, Inc., Fire Insurance Exchange, Stacy Chern Agency, and Ms. Chern for all kinds of contract breaches and tort damages. In May of 2019, the insurance defendants made settlement offers of $14,242.56 each to Chang and Lo, pursuant to Code of Civil Procedure Section 998. The offers each stated this offer expires the earliest of 30 days from the date of the offer or at the commencement of trial. In January of 2021, Chang, Lo, and Chang Jr. sued Farmers Fire Insurance Exchange, Chern, and their counsel, Wolves Beer, in a second action. The lawsuits were consolidated, and the operative third amended complaint deemed filed in July of 2021. Farmers demurred to the third amended complaint on numerous grounds which the trial court sustained and which the California Court of Appeal affirmed on appeal. As the matter neared trial, the trial court issued several discovery orders with which Chang and Lo did not comply. In November of 2022, the trial court granted a motion for terminating sanctions filed by the insurance defendants and entered judgment against Chang and Lo on the remaining causes of action for breach of the covenant of good faith and fair dealing, breach of contract, unfair business practices against the insurance defendants, and professional negligence against the insurance agent, Ms. Chern. Plaintiffs moved to strike or tax costs on multiple grounds, including that the expert witness fees were not recoverable because the matter was never tried, no invoices were attached, and expert witness fees are generally not recoverable as costs. The trial court disagreed and entered an order granting $14,849.75 in costs to the insurance defendants. Section 998 allows for recovery of expert witness costs in certain circumstances when an offer of settlement is not accepted and there is a judgment less than the amount of the offer. The statutory basis for the trial court's award of expert witness fees was Section 998. Once the offeror shows the Section 998 offer is valid, the burden shifts to the offeree to show that the offer was not made in good faith. An offer is made in good faith if it is realistically reasonable under the circumstances of the particular case, that is, if the offer carries with it some reasonable prospect of acceptance. Plaintiff made no argument that the Section 998 offers they received were invalid. The insurance defendants obtained a judgment in their favor on all the remaining causes of action brought by Chang and Lo. An award of zero damages, generally, if not always, constitutes prima facie evidence showing the offer was reasonable and the offeror is eligible for costs as specified in Section 998. Plaintiffs do not challenge the reasonableness of the expert witness fees that the insurance defendants sought, or that such fees were all incurred after the expiration of the 998 offers. Rather than addressing whether the expert fees were proper under Section 998, plaintiffs instead raised a number of other arguments that were disposed of by the trial court. Plaintiffs had the burden to establish the insurance defendant's offer was invalid or not made in good faith. Chang and Lo did not make any such showing. Accordingly, the Court of Appeals concluded the criteria for an award of post-offer expert witness costs under Section 998 were satisfied. The post-judgment order awarding costs was affirmed. Fire Insurance Exchange and Chern are entitled to recover their costs on appeal, as well as the costs awarded by the trial court. In my opinion, California's Section 998 is a tool available to defendants to encourage settlement. The insurers made a viable offer of settlement, which the plaintiffs refused. After the case was dismissed by the court, the defendants were entitled to their costs, including expert witness fees incurred after the offer was rejected. To appeal this issue is a clear act of desperation and is contumacious conduct of parties who never tried to even comply with court orders. I doubt personally that without a writ of execution, the farmers will ever be paid the costs ordered. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. And you will also gain access to the more than 4,950 blog postings. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.